Hi guys, welcome back. Today I want to share how I fought back against my employer's motion for summary judgment. And before we get into it, I need to say that I've touched on this subject before, but I'm getting asked about it all the time, and it's a really important subject, so we're going to talk about it again. If you have an attorney, you're going to want to let them drive this part of the process. But you can still use the tips that I'm going to share today to write down your side of the story and maybe give your attorney some things to work with. After my investigation concluded, NASA found that there was no discrimination, despite all the evidence of it in my report of investigation. And to appeal that decision, I had to request a hearing with an EEOC administrative judge. I assumed that requesting a hearing meant I was actually going to get a hearing. But I found out otherwise when the preliminaries and discovery ended and I got hit with NASA's motion for summary judgment. And I had to scramble to figure out what even is this and how do I even start to respond to it. We workers can file these kinds of motions too, and I know some of you have done that, but employers do it all the time. Now, I'm not an attorney, but in normal people speak, an employer's motion for summary judgment is a request for our judge to issue a quick decision in their favor without giving us a hearing. And the rationale for doing that is that the important facts of the case aren't in dispute, and those facts only support one possible interpretation, theirs. When I first started learning about summary judgment, I thought it sounded like a great idea. My evidence was solid, so I thought there was a really good chance that my judge might find in my favor. Until I found out that me winning was not a possible outcome of their motion. A motion for summary judgment is only asking the judge to do one thing. Essentially, they're asking our judge to throw out our case without giving us a day in court. In NASA's motion, they essentially justified anything that my boss wanted to do, no matter how illegal it was. And they did everything they could to make me look like a really bad employee who deserved to be treated that way. And be prepared, that can hit hard. I expected NASA to lie about the events around my request for reasonable accommodation, but I didn't expect them to just make up a bunch of stuff about me. I had to take a couple days to remind myself that it wasn't personal. It's just part of the dirty employer's playbook. Now, to decide a motion for summary judgment, our judge is supposed to look at all the undisputed facts around our claim and make a determination of whether there's an interpretation of those undisputed facts that could possibly support our case. And if there is, the judge has to deny our employer's motion for summary judgment and give us a hearing. So my strategy for responding to NASA's motion was pretty basic. First, I tried to show my AJ that their version of the undisputed facts was still very much in dispute. And I tried to show him where NASA's interpretations were off because they didn't consider all the actual facts. And I tried to back up everything that I had to say by either pointing to evidence that was already on the record or introducing new evidence. As an example, let's look at NASA's undisputed fact that I had communication problems that were so severe I couldn't even participate in the interactive process around reasonable accommodation. And to try to prove that, they brought up an incident from years earlier when I had a conflict with a coworker. And they spun it to make me look like the problem. In my response to their motion, I disputed everything they had to say about that, with evidence. To refute their claim that my boss had ever asked to discuss reasonable accommodation with me, I pointed to some evidence that was already in my report of investigation that NASA had overlooked. There was a bunch of email traffic showing that I'd asked to discuss it many times, and my boss always refused. And there were also emails that I'd sent to both HR and the diversity manager asking each of them to facilitate a discussion with my boss, which they never did. And to refute their claim that I had severe communication issues, I presented copies of every performance rating my boss had ever given me. And in each one, she had praised my exceptional communication skills. And I was able to refute their new spin on that old conflict with my coworker by presenting email traffic that went down between me and my boss at the time it happened. And those emails showed that my boss didn't blame me back then. In fact, she said it was the other person's fault. And I think her flip-flopping about that raised some serious questions about my boss's credibility. The only way a judge can really assess witness credibility is by seeing them testify at a hearing. I raised a lot of other factual disputes with NASA's motion, and together all those disputes convinced my AJ that the only way to resolve all those questions was by having a hearing. So that's how I beat summary judgment. I tried to show with evidence that NASA's undisputed facts were in dispute. And because their facts were off, so were their interpretations. The more we can do that, the more questions our judge is likely to have, and the more likely we are to get our day in court. See you guys next time. Till then, take care and hang in.